Juror Doe is juror number 5, and then at midday today we had juror number 6, and now we're going to read through those motions. Now comes juror E, filed at midday today. Now comes the defendant Karen Reid, by and through undersigned counsel, and hereby respectfully submits this second supplemental memorandum in support of her motion to dismiss, filed on the 8th of July 2024. As reflected in the attached affidavit of Alan J. Jackson, a fifth deliberating juror, Juror E, has confirmed that the jury was unanimous on 1 and 3, and that Karen Reid was not guilty of those charges. Based on the attached affidavit and all of the reasons set forth in its opening motion, first supplemental memorandum and reply, the defence respectfully renews its contention that the jury acquitted Miss Reid on counts 1 and 3, or alternatively there was no manifest necessity for a mistrial as to those counts, and therefore double jeopardy protections of the federal and state constitutions require that those accounts not be retried. If the court would prefer to rule on the basis of affidavits executed directly by the jurors, the defence respectfully requests permission to initiate contact with jurors A, D, and E for the sole purpose of asking them to affirm the accuracy of 3 affidavits of Alan Jackson. Alan Jackson's affidavit reads, I am a partner at the Los Angeles law firm. On Wednesday, July 17th, 2024, I was contacted by Juror E. Listen up, Bev. True name and identity withheld to maintain anonymity. Seems like nobody wants the jurors' names to be public. Certainly not the defence. Based on my conversation with Juror E and that juror's physical description of him or herself, where that juror was seated, and that juror's name and occupation, which was also disclosed during the voir dire process, I was able to positively identify Juror E as a seated deliberating juror in the trial of this matter. Juror E stated that he/she decided to contact me to provide information about the results of the jury's decision-making following the deliberations. Juror E explained that the jury was unanimous on 1 and 3, that Karen Reid was not guilty of those charges. Juror E went on to state that the only count on which the jury was deadlocked was in relation to the lower charges on count 2. I took that to mean the lesser included offences associated with count 2. Juror E indicated that he/she was happy to provide such information but wished to remain publicly anonymous. Again, Judge Bev, no one's asking for them to be public. The foregoing is true and correct, blah blah blah. Judge Bev has ruled on the order regarding Juror Doe's emergency motion to extend July 8 impoundment order, which was like 10 days ago. Like, nobody cares, Bev. This matter came before the court on the emergency motion of Juror Doe to extend the July 8 impoundment order entered by this court. Upon review of the motion and supporting documents, including affidavit, the court makes the following findings and order. 1. This case has garnered significant and divisive attention in Massachusetts and across the nations. Well, duh. You got a bunch of corrupt cops covering up a crime. What did you expect was going to happen? 2. Individuals associated with this case have been charged with intimidation, which charges remain pending. Which individuals? We only know of 1. 3. Juror Doe has submitted a detailed affidavit which I find to be credible. Yeah, it's credible gossip, Judge Bev. Every single thing is, oh, I read this on the internet and I saw that on the internet. None of it is actually first-hand experience. 4. Juror Doe is in reasonable fear for their safety and the safety of their family if this list of jurors is made available to the public. Yeah, well, who's threatening them, Judge Bev? I believe that's your side doing that. And if you have a look at the screenshot I took, you'll see this cowboy person is one of Judge Bev's cronies. Number 5, through their affidavit, Juror Doe has established that publication of the list identifying the names of the impaneled jurors will present a real and present risk of personal harm to jurors and the integrity of their service. Well, we don't care, Bev. Do it. Impound it, because that's not what we're after. We just want to know what it was that they voted during deliberations. 6, through their affidavit, Juror Doe has established good cause to extend the impoundment order dated 8th of July 2024 until and unless otherwise ordered by the court. Cool, it's indefinite. This order shall not preclude any juror from identifying him or herself and or from speaking to the public about his or her jury service. Oh, so you're going to let them volunteer it if they want to. So ordered, Judge Bev. Could have just done all of that, Bev, without bloody making a big show of it. But of course, who benefits if you make a big show of it? Your side, Auntie Bev? I don't even want to read the memorandum in support of emergency motion because it's just, I read this on the internet and I read that on the internet and I saw this on Twitter and I saw that on Twitter and people are cutting out remarks that other people have made and cutting it down so it looks really bad for the person who said it. That sort of gossip. So we won't be reading the gossip. Oh, we don't have Juror E's affidavit. Well, there you go. See, Judge Bev has impounded Juror E's affidavit, for fuck's sake. Anyway, let's have a look at the exhibits attached to Juror Doe's affidavit. Exhibit 1 is a hit piece written by Boston Globe calling Karen Reid supporters diehards, making fun of absolutely everything from the colour clothes they wore to what their kids were up to and what their signs read, quoting people out of context. Because when we say we are outraged, it doesn't mean that we are raging or that we are being animals. We're simply quoting something that the attorney said, along with a multitude of other out of context sound bites. None of it positive towards the supporters of Karen Reid. Exhibit number 2 is a story written by Aidan Carney himself about some of his friends wearing a Free Karen Reid shirt in the Waterfall parking lot being attacked by none other than Chris Albert. Exhibit number 3 is Jessica Machado, who is currently countersuing after being accused of harassing someone that she quite simply was not harassing. And then, of course, she turned up to court, but the other woman didn't, which should have been an instant dismissal. Nonetheless, she's being sued right back. And exhibit number 4 is, again, Jessica Machado, who was attacked by Grant out the front of the courthouse. He's that unhinged character that I've been posting about. The one who copied the 10-2 jury gossip. After he assaulted Jess, she took a restraining order out on him and she won. And I dare say she'll win this other case that was in the previous exhibit. And also, this Julie Carr 94 account was quoted. It's not actually Aidan Carney's own words. It's just someone saying, how long until he unleashes abuse against the jurors? And yes, Aidan has opinions about the jurors. Big fucking whoop. All he has ever said about their identities is that he hopes they come forward. Unlike the other side, who has written things like, Dear Karen Reid jurors, your jury service is complete. You have lost all rights to remain anonymous with these additional filings by the defence. We have a right to your identities as you try to circumvent the laws of our Commonwealth. Or how about this post here? First word said in the jury room. She is at least guilty of manslaughter. Kudos to Mad Jack because nobody should know what was said in the jury room. That is illegal. Not putting a mic in someone's face, trying to record an interview. Not protesting peacefully, holding signs and wearing pink. Influencing a jury in the jury room. That's illegal. I don't think I'm allowed to show you on YouTube what kinds of threats have been made against Karen Reid's life. Anyway, I just wanted to show you that all of the attacks, all of the violence, all of the social media ruckus and threats and everything is not coming from the Free Karen Reid side. It's coming from the McAlbert's side. As I said in the last video, they have a reason to be shit scared right now, and they're showing it. So yeah, way to go, Juror in showing your obvious bias. I mean, how hard did you have to dig to find all that negative stuff about the FKR side? Whenever I type Karen Reid into the search bar, I have to dig really, really deep to find any of those negative posts. In order for Juror to have seen them and felt threatened by them, Juror had to already have that bias. And lastly, I am not going to do a mashup of all the attorney reactions to this because I don't agree with them. Yes, it's an affidavit, but it's just talking about gossip. So how can you sit there and say it must be true, or it must be valid, or it must be credible? The day that gossip becomes credible in a court of law will be the day that I lose all faith in the system 100%. I kind of feel like I don't have much faith left to lose. How about you? Well done, Auntie Bev. You really kept the faith in the justice system happening, didn't ya?
District attorney went off the rails. Innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged. Before any trial has occurred, he announced the defendant's theory of the case is a desperate attempt to reassign guilt. That is outrageous. We are outraged. He provided a false notice of discovery, claiming he did not know. We now know that was a lie. That is outrageous. We are outraged. This court should be outraged. Everyone should be outraged. That is outrageous. We are outraged. District attorney went off the rails. Innocent until proven guilty. Never came out of his